If I move to the fourth current petition, and apologies, this is a slightly lengthier preamble by myself. It's PE1458 by Peter Cherbi on the Register of Interest for members of Scotland's judiciary. Members have a note by the clerk, it's paper 7. Members will recall that it was agreed that this petition should be considered again once myself and Chic Brodie had met with the Lord President. I can advise that we had a useful meeting with Lord Gill last week. We discussed what Peter Cherbi's petition is looking for and the current procedure for members of the judiciary to recuse themselves. Lord Gill confirmed that recusal in any case is noted in the minute of court proceedings, which is part of the formal court process, but no central aggregate records of individual records is kept. So that would mean for an ordinary member of the public, it's almost impossible to detect how many recusals there's been across Scotland at any particular time, or for any individual sheriff or judge. But Lord Gill explained in more detail why I felt the Register of Judicial Interests would not be workable, the principal reason being that a judge cannot predict what could arise in each and every court case that might come before him or her. In any event, the petition seeks a register of pecuniary interests, and such a register would not address some of the concerns raised by the petitioner, for example, about undeclared family relationships. What I can say, though, on the suggestion of Chic Brodie and myself, is that Lord Gill has undertaken to check with the Court's administration to see whether their IT systems can be adapted to provide aggregate information about recusals, and he's undertaken to write to me in the next couple of weeks. Clearly, we're still awaiting that response, but if that was possible to organise, it would mean that ordinary individuals with an interest here could find out how many recusals there were across Scotland by which sheriff or by which judge. So my personal view was that it wasn't accepting, obviously, the petition, but it was moving in the right direction. I thought that was a practical step. So I'm merely reporting to the committee responses from Chic Brodie, and Chic Brodie may wish to have additional comments.
Yeah, I think it was a reasonable meeting. I think also that the Lord President drew to our attention the fact that those that sit on the board of administration of SCS have to register their interests with the board. All members of the board have to register their interests. So, in fact, unbeknown to us, their interests were already in the public domain, and I think, as part of the letter, unless I'm wrong, that he would include in that letter a wider understanding, and he would talk to his colleagues about expanding that. That's
true, and just so that members are totally in the loop, clearly there's only a small number of judges involved in this, but the procedure that Lord Gill is going to look at, I think has some merit. But my suggestion to the committee is we wait until we get the full letter from the Lord President, which, taking Jackson Carlo's point, won't be forever, will be in the next couple of weeks, so that we can look at this issue in full. I'm just summarising my account of the meeting, but I'd like to obviously see what the Lord President's view is. Jackson Carlo?
I would only observe, Convener, that but for the belligerence of this committee in pursuing the issue, there would be no letter forthcoming, and there would be no investigation or other actions potentially arising from it, or explanation. So I think it rather vindicates the tenacity with which we've pursued the matter.
John Wilson?
Convener, just I would request a response in relation to was there a record taken or a minute of the meeting that took place between Lord Gill, yourself and the Deputy Convener?
The clerk was present and took notes in the meeting. Obviously, it wasn't an official meeting of the committee in the sense that we didn't have official record on that. But if you want an account of that, that's certainly something we can follow.
I certainly, just on that, would wish... Sorry.
John Wilson?
No, Convener, it's just that one of the issues that arose was the issue of Lord Gill refusing to come to this committee and give evidence. The compromise position was that yourself as convener and the Deputy Convener would meet with Lord Gill. What I'm interested in the interests of natural justice, is that we have something as a committee that we can put on official record to declare what took place at that meeting, so that we can actually satisfy, I think, future petitioners that we are not in a position, or would not be in a position, to hold private discussions with individuals who we ask for evidence from that may basically avoid them actually putting something on the official record. And that, as I said, I think that's been my position all along in terms of this debate, with Lord Gill, that we required something to be put officially on record. But I also welcome the fact that Lord Gill is going to write to the committee with a fuller, detailed explanation of what actually happens in the judiciary in terms of recusal and the declarations of interest. So that, I think we have moved slightly, but as I said, it's still the issue about Lord Gill's refusal to come to give evidence at this committee.
Yeah, I mean, in terms of John Wilson's point, there's no difficulty at all getting an account of it. I did make that point to Lord Gill at the start, that we would be making a summary of the key points, and so before he said anything, I wanted him to be clear that was the nature of it. And just, I mean, all members were familiar. Obviously, Chic Brodie and I met Lord Gill on the agreement of the committee. We weren't doing this, obviously, in any sort of secret way. And members will also be aware, and I don't want to reopen at this stage, but clearly there is issues which Chic Brodie raised, that under the Scotland Act we don't have the power to cite a judge or a sheriff before us. You'll notice from Justice Committee, obviously, if the judge or the sheriff or the Lord President indeed wishes to attend voluntarily, he or she is able to do that. And I think Chic Brodie put a very thorough point to the Lord President on that particular point. But I'll make sure that that note is contained in the next meeting. And obviously, in this sense, we are putting on the record what happened. Sorry, Chic Brodie, you were wishing to come
Yes,
in.
sorry, I was going to make that point, Convener, in terms of, I think it's section 23(7) of the Scotland Act. There is no compulsion, funnily enough, on judges and, in fact, leaders of tribunals to either come to committees or produce documents, which I find wholly unsatisfactory and a flaw in the Act. And in looking at the evidence and looking at the parliamentary report in 1998, I think it was, the argument for that seems to have disappeared in the mists of legal jargon. In fact, there was hardly any debate on the issue. All of a sudden, it transpired that with the creation of the Supreme Court earlier, that prior to that, judges were required to register their interests. All of a sudden, they weren't, and with not much debate. And I think on an ongoing basis, not for this committee at this stage, but on an ongoing basis, we need to ask the question, what actually happened and why was this decision made? But I think, all in all, it was a fairly favourable meeting. Yes. And I would like to thank the committee, because I know it's, in allowing me as part of the team to participate in that meeting with the Lord President.
I thank members for the contribution. Are members then agreeable that we await the letter from the Lord President and we discuss this once we have the letter in front of us? And thank members for their contribution, and thank Chic Brodie for coming along with me to that meeting.